This episode is sponsored by my new online course, Mineral Management Basics. Understand what you own, gain the power to manage your minerals and royalties. Did you first find out that you inherited mineral rights or royalties from a phone call or a letter from a landman or mineral buyer? Do you want to have a better handle on what it is that you own so you aren't caught off guard next time? If you're like most people, you want to learn all you can about being a responsible and informed mineral owner. I'm going to help you cut through all the confusion to not only learn more about your existing mineral rights and royalties, but to also equip you with the tools to find out if you might own other interests that you don't currently know about. In Mineral Management Basics, I'll walk you step by step through the process of finding out exactly what you own and where it is located, with high-quality videos that aren't too long and examples along the way. You'll be able to locate your mineral and royalty interests on a map, perform your own title search, and identify nearby oil and gas activity. Your interests are depending on you to find them. Go to mineralrightspodcast.com and click on courses to learn more and sign up today. Again, that's mineralrightspodcast.com and click on the courses link to learn more.
Are you ready to make the most of your oil and gas mineral rights? Welcome to the Mineral Rights Podcast. Get the knowledge and resources you need to manage your minerals and royalties. Here is your host, Matt Sands.
Hello and welcome to the Mineral Rights Podcast. I'm your host, Matt Sands, and I'm here to help you make the most of your mineral rights and royalties. And my co-host, Justin Williams, is here with me as always. Hey, Justin, how are you doing today?
Good morning, Matt. Doing well.
So, Justin, we have an interesting episode this week. As many of my listeners know, I put together an online course, and this course covers the things you need to know if you're a beginning mineral interest owner or an aspiring investor and you want to understand the ins and outs of this asset class. So, Justin, we're going to talk about the first module of that course and most of the content within that module, just to give people a sneak peek as to what to expect from this course. Before we dive in, I think one of the things that people may wonder is, do I own the mineral rights under the surface of my property? Maybe you're out in a rural area where there's oil and gas development. You're getting offers to lease or perhaps receiving royalty checks, which would be a good indication, of course, of owning the mineral rights below the ground. And then the other question that pops up, Justin, is what's the difference between the surface rights, mineral rights, and then what are royalty interests compared to mineral rights? I had a conversation with a gentleman that's looking to start investing, and he really was asking questions like, if I'm looking to buy a mineral interest versus a royalty interest, what's the difference? So that's one of the things we're going to talk about, but is that the case in your situation as well?
Yeah, I couldn't agree more, Matt. And I think for a lot of mineral rights owners, once they inherit it or they purchase it or however they come to know that they own mineral rights, there's a specific question that you're looking to answer. But a lot of times that can get really confusing because you really have to understand the fundamentals of what this property ownership is and how it works, so that as you're learning the more information as you get further in, you need to know what those terms mean. And I think that is a big thing for a lot of mineral owners, is that they don't have that foundation, which is exactly what this information is.
That's a great way to put it. This is the foundation to understanding and doing the things to make the most of your minerals and royalties. And this is really the understanding of what exactly mineral rights and royalty interests are. And so that's what we're going to cover. Again, this is a sneak peek of that first module in my course, just to give you an idea of the type of content. And of course, it goes more in depth than this and into some very specific and actionable things, which we'll talk about at the end as well. So, Justin, do you want to talk about the concept of property and what exactly is property?
Absolutely. In legal terms, property can be described as a thing that is owned or possessed. That seems obvious. But the next question is, what type of property are mineral rights? Property can be classified as real or personal. Real property is the land and associated permanent fixtures such as buildings or homes. Since oil and gas and other minerals are considered to be part of the land, they are considered a form of real property. With mineral interest, there are several different ways you can come to own them. You might own both the surface and the mineral rights below the ground. You might own just the mineral interest that may have been severed from the surface rights, or you could only own the surface rights but not the minerals. And Matt, there's some very specific legal terms that specify exactly what that ownership means. And the first one is fee simple. And this is really owning it all. But do you want to talk about the details of that?
Yeah, fee simple is sort of the umbrella term if you own all of the rights. And so that's absolute ownership of all aspects of a property. And again, this is a form of real property. So it is something that is owned indefinitely. In most cases, we'll talk at the end about the concept of dormant minerals, but in most cases, and especially with fee simple, where both the surface and the minerals are owned together, it is something that is an indefinite time period. So it's in perpetuity is a term that's used. The fee owner owns both the surface and the mineral rights below the ground. As such, the fee simple owner does have the right to grant mineral or oil and gas leases. So it does have the executive rights, which is one of the key rights that comes along with owning mineral rights. Now, Justin, it's very common nowadays, though, to see where the mineral rights have been separated from the surface rights. Do you want to talk about that concept of severed minerals?
Absolutely. And Matt, in my experience, I don't know that I've come across fee simple properties. Most of the time, what I've seen is severed minerals. And in many states, those mineral rights can be separated from the surface rights. It's called a split estate when it occurs. And when the original fee simple owner transfers that ownership of only the subsurface minerals, and when the minerals are severed and split from the surface rights, it's done using a deed to convey the subsurface minerals separately from those surface rights. The person who owns this mineral interest is called a mineral owner. In most cases, the mineral owner is still entitled to the use of the surface as reasonable and necessary for the recovery of those minerals. This feature is called the dominant estate. That is, the mineral interest owner has priority over the surface owner as it comes to being able to access those mineral interests below the ground. And Matt, this is just something we've talked about a lot in past episodes.
Yeah, and when we refer to mineral rights, this is usually the situation, like Justin mentioned, that people find themselves in. Maybe they've inherited severed mineral interests. In other words, just the separate mineral rights, but they don't have an interest in the surface rights. There's a couple different ways you'll see this done as you review documents with the county clerk and recorder. And that is where the surface rights are conveyed, but then they might reserve the mineral interest. So you'll see a clause in that deed where the grantor or the previous owner kept those mineral interests and sold the surface rights. And that's when that separation would have occurred and that severed mineral interest begins to exist separately from the surface rights. Another way it could just be through a simple mineral deed where I'm conveying the mineral interest to a certain party. So maybe that's where it starts. And so there's a couple different ways that the minerals can be severed from the surface. But again, it just goes back to using a deed to do that. So when you have surface rights only, and most residential properties are in this category where you own only the surface rights, maybe the developer maintained ownership of the minerals under the ground, or maybe the city owns the minerals. And so you just have rights to use the surface land and the associated permanent fixtures, such as a house or a garage or whatever. The surface owner does not have the right to grant an oil and gas lease, which kind of makes sense because they don't own the mineral rights. And again, this is just called the surface estate. So we have this concept of the mineral estate belonging to the mineral interest owners, and then the surface estate belonging to the surface owners.
Absolutely. And Matt, when you get into the law side of property, so there's the real property ownership rights. And when it comes to real property, there can be several different rights that the property owners receive when acquiring a title to a tract of land. In property law, there are different rights that are often called bundles of rights or bundles of sticks. We covered a few of these already, and there are several other rights associated with real estate in general. But because we're focusing on minerals, we're going to try to focus on the ones that are relevant for mineral interest. These rights are important because they dictate what you can and can't do with your property. There is the right to lease your minerals, which is called the executive right, the right to receive bonus payments, the right to receive delayed rentals, and the right to receive royalties. An interesting feature with royalties is that you can convey or transfer some or all of your right to receive royalties. One way, Matt, that this can be done is through what's called a non-participating royalty interest, or NPRI. This allows the owner of the mineral estate to retain the executive rights for that lease to sign and receive a bonus, delayed rentals, and payments associated with that lease, while transferring a portion of the right to receive royalties to another person. And Matt, mineral rights can also be subdivided into smaller parts of the whole. And this is something that we see a lot through inheritance and that kind of thing. For example, Joe owns 100% of the mineral estate. He gives an equal share to each of his two children, Mark and Sarah, when he passes away. Mark now owns 50% of the mineral rights under the farm, and Sarah now owns 50% of the mineral rights under the farm. And while it depends on the exact wording of the deed, most of the time, When the mineral estate is split, the bundle of rights are split equally as well. In other words, in the example, both Mark and Sarah would have the executive rights to separately lease their portion of the inherited mineral interest and would get their share of the lease bonus and their share of the delayed rental payments.
Yeah, and that's an important concept. And Sarah and Mark would each own that undivided right to 50% of all mineral interests and would not need each other's consent to exercise those rights. So this means that if Sarah wanted to lease her interests and Mark did not, each would get to make their own decision. So they wouldn't have to work together necessarily to lease their minerals. On a side note, I will say that it is beneficial sometimes if you own minerals with cousins or with siblings. If you pool your resources and if you work together, if somebody approaches each of you to sign an oil and gas lease, it's better to negotiate as a team and say, okay, well, it's kind of an all or nothing thing. Maybe each of you own 10 net acres, but if you negotiated together and there's 4 siblings, you would be negotiating on 40 net mineral acres and you'd have more power with the operator just because you have a larger interest that you're negotiating on behalf of. So that's a side note and a tip for siblings and family members that own undivided mineral interests in the same tract of land. It's better to work together in most cases. Again, if you can get a critical mass of minerals together where you might have more bargaining power. So that's an important thing to think about. The thing that is important as you get mineral interests that may have been subdivided multiple times or dozens of times. And if you own an undivided interest in the minerals, you also don't have to track down the dozens of other owners to get their approval. So that is an important concept with undivided mineral interests. And I see this as a common question from new mineral owners. We're thinking about selling, but my cousin doesn't want to sell or my sibling doesn't want to sell. And sometimes I think there's this impression that, well, we all need to do it together. It's an all or nothing thing. But in this case, if you have an undivided interest, you don't. You can do it on your own if you want to sell or to lease. Whereas maybe if you have a relative that doesn't. So, just an important thing to think about. Just to summarize here, there are several different types of rights that go along with owning real property. Mineral rights are one of them. And of course, that's what we're most interested in because we're the Mineral Rights Podcast, right? So that's what we do here. And so the ownership of the mineral rights comes with the implied right to develop the minerals. So in other words, if you own the mineral rights, there is this implied right that the surface estate can be used to explore or develop the mineral interest below the ground. And you have to compensate the surface owner for any damages, but it's an important concept. And that's that dominant estate that Justin mentioned. And it gives you the right really for a company because most mineral interest owners don't go in and drill their own wells. They lease their minerals so that somebody with the capitalization and the knowledge can come in and deploy that in drilling a well and producing the oil and gas under the ground. And then you would receive a royalty payment as a result of that production that's sold. So it's not something we're going to cover in detail here, but again, most mineral interest owners that I talk to and work with lease their minerals to an oil and gas company to explore and produce because they can't do it themselves. And Justin, I know you had an interesting anecdote in kind of doing the title search for your interests and some common practices in terms of one of those tools that's in our tool belt as a mineral interest owner, and that's the concept of that non-participating royalty interest. Do you want to talk about that?
Yeah, absolutely. So in West Texas, and this is the case with several of the interests that my ancestors received, the game plan was to go in, buy the rights from an individual. They would then take those rights, hold the executive rights for leasing, the delayed rentals, the bonuses, and then sell off that NPRI to other people to recoup the cost that was spent buying the property. And that is fairly common. And there's a lot of owners today that have NPRI, and it's a result of doing that and different deals that happen that way.
Yeah, and that's a useful tool in your tool belt if you're looking at selling some or all of your mineral interests. And maybe there's a way that you can maintain some control. In the case, if you want to maintain control over the terms of the lease, you get the full lease bonus versus subdividing your minerals even further. If you sold half of your mineral interests and only receiving half of the actual lease bonus when you sign a lease, it might be better to sell half of your interest in terms of a non-participating royalty interest. So you retain 100% of the lease bonus amount, and then you sell a part of those future royalties effectively. A side note, an NPRI is a perpetual right. So it's something that would last over time. And so it is something that you could use to grant a royalty interest to your children, and you could maintain the executive rights while you're still alive. Maybe you're familiar with oil and gas and how to manage minerals and leasing, and you're comfortable with that, and you'd rather retain that executive right and then grant your children a non-participating royalty interest. Maybe they're minors, or maybe they just aren't quite there in terms of their journey and understanding this particular asset. And so that can be a useful tool as well if you're looking at perhaps granting some of your interests to children or grandchildren or nieces or nephews or that kind of a thing. So
Matt, and I think non-participating royalty interest is definitely not one to confuse with overriding royalty interest, which we're going to talk about later. But as you said, they can be a great tool. And I think a lot of people, when they are thinking overriding royalty interest, they can achieve what they're thinking through non-participating royalty interest.
yeah, that's an excellent point. And you brought up an interesting point before we hit record, and that's the concept that a recorded oil and gas lease infers ownership, but it doesn't prove ownership. And so as you're doing title searching and reviewing the records in the county courthouse, and you come across an oil and gas lease, and perhaps it was something that was signed for an individual that maybe you're looking at investing in a particular area and you want to understand who the mineral interest owners. A recent oil and gas lease is a good indication that they probably own the minerals still. It infers ownership because the assumption is that the lessee would have done a title opinion or obtained a title opinion before leasing to understand who the actual mineral interest owners are. So that's something that you can use as kind of a tip if you're just getting started investing, or if you are doing a title search and want to understand, did your relative own the minerals at a particular point in time? And so if they had signed an oil and gas lease, maybe there isn't a mineral deed or a deed where it shows that they retain the minerals that you can find initially. But again, in a more recent time period, maybe you find an oil and gas lease that they granted, then that might be a good indication that they had owned the mineral rights at that point in time. So useful clues that you can find. And this is all sort of like putting your Sherlock Holmes hat on and trying to unravel the mystery of the ownership of your interests. And this is a very common journey that mineral owners have to go through, whether they inherit them or if they're looking to invest. And there's ways to confirm who owns that. And we'll talk about that a little bit at the end. But that is part of this course in terms of how to perform a title search, which is the way you would go about doing that. So, Justin, you want to talk about some of the differences between different states and then some of the other resources we have available related to this?
Absolutely. So something that I think can bring up a lot of questions and how it differs is rights and responsibilities can really vary from state to state. And some states also have what's called dormant mineral statutes that require certain actions to be taken in order to keep your mineral rights and prevent them from reverting back to the surface estate. This area can get really complicated really quickly and again, varies state to state. So if you have questions, be sure to contact a qualified attorney licensed to practice law in the state where you own those minerals, because there's really no better person to be intimately familiar with what that state requires and making sure that you stay compliant with that. Matt, we've also talked about these different types of interest during the podcast over the years. And we have our episode 2, what's the difference between minerals and royalties? And then we also go into dormant mineral statutes in episode 66. And, it really is meant to help answer the questions, do my mineral rights expire? And thankfully, I have my minerals in Texas. I've never had to deal with that. Not yet. So different types of minerals and interests. So it's pretty simple as it relates to oil and gas. Mineral interest can be either producing oil and gas interest or they aren't. Either, those minerals are being produced by an oil company these days, which is more common, or they're laying dormant. And as with a piece of land, it can either be vacant, or if it's in a residential area, for example, it could be developed and have a house on it. Or it might be partially developed and maybe it only has a garage but no house, but there's room for the owner to add a house in the future. Similar with mineral interest, if they're producing oil and gas, they may be fully developed with no room for any additional wells, or partially developed with room for the oil and gas company to come in and drill additional wells in the future. When a property is either partially or fully developed and has one or more producing wells on it, the mineral interest owner usually receives a royalty payment. The interest in these producing wells is often called a royalty interest. This is a general term that refers to the right to receive those royalty payments. And as we discussed previously, there is a type of royalty interest called a non-participating royalty interest, which allows that owner to receive the portion of the royalty payments of the oil gas that is sold, but not give them the right to lease the associated minerals.
Yeah, that's a key point, like we talked about. And sort of a side note here is you don't necessarily need to be receiving royalty payments from a producing well in order to convey a non participating royalty interest. So, just to clarify that, when we say royalty interest, in general, it does refer to the right to receive royalty payments, and it infers that the interest owner is receiving those royalty payments. And so, you'll see on your check stub an RI next to the interest type, and that just indicates that this is a royalty interest. Now, that is usually derived from that mineral estate. When you sign an oil and gas lease, you begin by agreeing to a particular royalty rate, and that will be something that factors into the royalty interest and the royalty payments that you receive from that well when it starts producing. So, again, those non participating royalty interests are very useful tools, and it's a way that you can enjoy the benefits of current or future royalties while keeping you in control of the terms of any leases that are signed. Or, again, like we talked about, it can be used to generate some cash now to pay bills while keeping the full benefit of leasing your minerals in the future. It's an interesting feature of ownership of mineral interests. And everything we've covered so far includes the rights and benefits associated with the mineral estate. But what happens when you sign an oil and gas lease and what rights are created through that instrument are called working interests. And that becomes from the leasehold portion of things. So, Justin, you want to start by going over the different types of working interests?
Absolutely. And I know for me, Matt, even when I was starting to get a grasp on some of these other areas, working interests were a whole new kink to throw into it, but it's a very important part of it. And so when you sign a lease, you grant an oil and gas lease to a company to go drill a well on your land. And you're effectively conveying that mineral estate to that company for the term of that lease so that they can explore or develop the minerals. This creates what is called a working interest because they do all the work to drill a well. And at the same time, it reserves a royalty interest for you should they end up producing minerals such as oil and gas from that tract. For example, if you own 100% of the mineral estates and that is part of a drilling unit and you receive a 20% royalty in the oil and gas lease, the lessee will receive 80% of the production from any wells that are drilled, and you would receive that 20% production from these wells. So in this example, you'd own a 20% net revenue interest or NRI in those wells, whereas the lessee would own an 80% NRI and a 100% working interest. And again, this is really just the way to structure out that the oil and companies taking the ownership for going and producing those wells, the operation of those wells, and then you're receiving a royalty. Just like with mineral interest, there can be multiple working interest owners associated with a tract of land. And this is because each mineral owner with executive rights can sign an oil and gas lease covering their undivided interest to lessees. In fact, these undivided mineral interest owners don't have to sign a lease with the same lessee. So there usually ends up being multiple working interest owners for a given tract if it has been subdivided between multiple owners. In any case, the net revenue interest must add up to 100% between all the royalty owners and working interest owners. And the working interest must add up to 100% as well. And in a layman terms way, what this is basically saying is that there's multiple oil and gas operators that all work together on a well. There's people who go out and buy leases from individuals and then with the intent of working with those oil companies. There's all different ways that this can happen. But as mentioned, it all has to add up to 100% at the end of the day.
Yeah, and it all has to add up to 100%. And you'll hear the term non-operated working interest. And that is what Justin is referring to, where you have usually the minority lease owners that pay their proportional share of the operating costs and they receive their proportional share of the proceeds from any sale of oil and gas. And so there are usually multiple working interest owners, like Justin mentioned, in most wells, unless there was maybe one owner under the entire drilling spacing unit. That is the entity that the operator signed a lease with. In that case, there may just be one working interest owner. But in most cases, you have, again, because there's so many different mineral interest owners underneath each spacing unit, you end up with multiple working interest owners as well.
Absolutely. And another interesting feature of working interest is that the leaseholder can carve out a specialty royalty interest out of the working interest. And this is called an overriding royalty interest, or ORRI. Overriding royalty interest is a very interesting one, and it's not uncommon. The overriding royalty interest is created from the working interest, but it's not responsible for the cost of production, which is an interesting feature since it's part of the working interest. It doesn't affect the royalty interest payable to the mineral owner. So if you're the mineral owner or the lessor of the lease, you're not being affected by this. The limitations associated with an overriding royalty interest are that it shares in the income of the production of oil and gas as long as the associated lease is in effect. Once production stops and the lease expires, the override also expires. And this is different than most royalty interests that are part of the mineral estate, which are perpetual in nature. And man, I think this gets really confusing for a lot of mineral owners because in my case, I inherited an overriding royalty interest because my ancestor was part of the oil and gas industry. Some people may inherit this because their family was a landman or a geologist or maybe even an oil and gas attorney. So this can kind of get confusing, but it is something that can be passed through generations if the lease is still active, which is, again, not uncommon.
Yeah, and that's the big question. And that's something you'd always want to check is if you think you may have inherited an overriding royalty interest, is that you would likely need to go into the State Oil and Gas Commission website and see, has there been a well that is capable of production? What you would need is a continuous period of time where you have production established. Now, the terms of federal leases is something slightly different. Sometimes those are quite a bit longer. Most oil and gas leases signed with individual owners are 3 to 5 year primary term. Federal leases might have a 10-year term so that you could be within that primary term still, even if a well was drilled and it only produced for 5 years. And then there was a gap before another well was drilled. Well, as long as it was still within that primary term, that lease would be active. But in most cases, you would need to see continuous production or at least wells capable of production over that time period to see whether or not you might still have an overriding royalty interest in that particular lease. So that's, something to think about. And then if you're investing in minerals and royalties and you see an overriding royalty interest, you got to keep in mind that this will expire once that underlying oil and gas lease expires. So it's not the same as the mineral interest where maybe a well produces for a while, gets plugged, and then a period of time goes by before a new oil and gas lease is signed and then a new well is drilled. If you're the mineral interest owner, you get the benefit of those future wells that are drilled. If you're an owner of an overriding royalty interest and the well is plugged and a period of time goes by, you're out of luck if a new well gets drilled in the future because that underlying lease had expired. So something important to keep in mind with those types of interests. And like Justin mentioned, it's often something that was granted as part of compensation for their work. And especially if you're a landman, you might have a target royalty rate and anything that you can negotiate below that, they might give you a cut of that difference. And so maybe they would retain an overriding royalty interest on those leases that they negotiate on behalf of an operator for a contract landman, for example. So it's an important part of the development of oil and gas. And this is something you'll see all these different types of arrangements that occur. You have payment in terms of an overriding royalty interest for work that's done on a project, or maybe they might have different partnerships, which get very complicated, but there's very creative ways that working interest owners work together and different types of deals that are done. So there are other situations as well where mineral owners might be faced with the decision on whether they want to become a working interest owner by participating in the cost of drilling a well. And in which case, like we talked about, there's that non-operated working interest owner concept. And that's what you would become if you are faced with this situation and you do elect to participate. And this is a scenario that mineral owners might face if you are unleased and you receive a pooling notice and you decide not to sign an oil and gas lease. So even if you own mineral rights, it is critically important to understand what a working interest is, both just to understand who the different parties are in this arrangement, or because you might unknowingly become a working interest owner if you're not careful. And again, a working interest owner is the person or an entity that has ownership in an oil and gas lease or a leasehold interest, and it provides that owner with the right to explore and produce oil and gas and other minerals. And the other thing that's important from a mineral owner perspective is then all of a sudden you bear proportional share of the cost of drilling, completing, and operating a well in return for your share of the oil and gas that's produced. Now, again, we talked about non-operated working interest, and that's the party that owns an oil and gas lease but doesn't actually do the work of drilling the well and of checking on the well and doing the maintenance and all of those things that go into keeping a well producing, and that it would go fall on the operator. And so the operator, when we say that term, we're referring to the entity that actually operates those oil and gas wells. Now, the company that drills the well is usually called the operator, and there can usually only be one operator for a given lease. And so it's the first to market sort of a thing. You'll see a lot of times companies will lease up a bunch of acreage and try to establish a majority position and then go and permit the wells. And the first one to go and permit those wells, if they go and drill them, they become the operator usually. Now, there's other agreements that get put into place that cover the rights and responsibilities of all the parties that own the oil and gas leases within a particular unit for one or more wells. And those are called joint operating agreements, or JOAs. So again, that's an important document that would govern the actual things, rights and responsibilities. But that is something that is potentially you would become a party to if you become a non-operated working interest owner. So Justin, you want to talk about the rights and responsibilities, and more so the responsibilities if you do become a working interest owner? What does this mean for a mineral owner that gets put in this situation?
Absolutely. And so each working interest owner that elects to participate in the drilling of a well, typically that will come with a financial contribution to the direct cost of drilling and completing that well. And then they'll receive their proportional share of the proceeds from the sale of the oil and gas. And the working interest owner bears the proportional share of the cost for that drilling, completing, and operating. And then there's also the plugging and abandoning side of things once the production comes to an end. And so as a working interest owner, you are responsible for all of that. And I think for mineral owners, that gets them into a scary situation. There's also the option, Matt, of becoming a non-consenting mineral owner. And that usually happens by avoiding negotiating an oil and gas lease. So that's not something that most mineral owners have to deal with, but it's part of a consequence of not signing a lease. With that non-consenting mineral owner, Matt, you're still basically a working interest owner. However, they realize that you're not going to financially contribute to that well or sign a joint operating agreement. So there's a certain way that they go about holding your royalties to help pay for that working interest responsibilities. And Matt, I know it's kind of gray on the back end because mineral owners can still get hit with the cost to plug and abandon as far as their proportionate share, even if you are a non-consenting mineral owner.
Yeah, and that's an important thing to think about. Now, you would still receive the statutory minimum royalty rate in most cases, and it, of course, varies by state as to what that amount is and how that's covered. But it's important to note that if you own mineral rights in a state that allows statutory pooling, and you again don't agree to sign an oil and gas lease, you may find yourself where you're becoming a non-consenting party, like Justin mentioned. And if you're a non-consenting party, you are actually choosing to eventually become a working interest owner. One of my favorite Rush lyrics is, if you choose not to decide, you're still making a choice. And so that's the situation you're faced with here, is if you're becoming a non-consenting party by saying, I don't agree to these terms, I don't want to sign this lease, and I'm not going to negotiate, or for whatever reason, you're actually backing into a non-operated working interest. And again, you would receive a smaller royalty rate. So let's say the going rate in your area is 20% royalty. If you signed an oil and gas lease, that would be likely what you would have received. Well, if you're force pooled and say, no, I'm not going to agree to that, maybe you would be faced with only receiving a 1/8 royalty or a 15% royalty. And then basically the remaining part of your proportional share of the proceeds from that well would become that non-operated working interest, and you wouldn't receive any proceeds from that until a penalty were enforced. So basically, because the operator is having to carry your non-operated working interest and the associated proportional share of the cost of drilling and completing that well, you would basically not get that portion until maybe 200% or 300% of that initial cost are paid back. And so it could be quite a while. But then once that penalty amount is fulfilled, you would back into that non-operated working interest and you would get the full amount of your proportional share in that well. Now, it's a situation that mineral interest owners may not realize that they're putting themselves in if they go non-consent. And there's a lot of pros and cons to that. And I would say that usually most mineral owners are better off signing a lease and just staying a royalty owner. You don't have to deal with the cost and then the liability. Like Justin mentioned, when they go and plug that well in the future, you're going to get a bill for that as a working interest owner because you're, helping to pay your proportional share of the cost for operating, maintaining, and then eventually plugging those wells. So we have some additional resources. If you find yourself in this situation, definitely do some research on your state, understand what your rights and responsibilities are. But we have a couple of episodes that we'll talk about here in a minute that cover that. So Justin, you want to talk about some of the other ins and outs of this and some of the other considerations and kind of close us out?
Okay, so to summarize, Matt, the other types of interest associated with the oil and gas is the working interest, and which is created when an oil and gas lease is signed. The overriding royalty interest or override is not responsible for that cost of production. It is part of that working interest. The operated and non-operated working interest owners are responsible for that cost of production, and in turn, they enjoy their share of the production. And as Matt mentioned, this isn't a game that most mineral owners find themselves in. We do see cases where people have inherited working interest. And there are times that, like Matt mentioned, if you don't sign a lease, you can end up in the working interest bucket, but it's not the most common. And Matt, we've done some shows on this that go pretty in depth. We had our episode 7, working interest for mineral owners. And then for overriding royalty interest, we did episode 43. And it really goes further into detail if you have some questions. But this is really an area as well, Matt, to speak with an attorney wherever you have your minerals. They will be able to really know more about that working interest and what that means to you in your area.
Yeah, and rest assured that if you are force pooled, you still retain ownership of your mineral interests and you could still sell your interests. And in some cases, you may still be able to negotiate an oil and gas lease after the fact with a third party who wants to take on your non-operated working interest, or maybe even the operator. So I know, Justin, you've found yourself in this situation, but again, it's not something you want to bet on, especially if the well is not very profitable. You may not get very much for that, or maybe you won't be able to find anybody willing to take that on. So that's something to think about. Any other tips you have, Justin, for people that find themselves in that situation?
I think for me, going to an attorney was really what made the difference. They was able to explain kind of what my options were. In my scenario, at the time, there were some really significant leasing bonuses in the area. So one of the better things that I could hope for was to find a third party and take that leasing bonus, knowing that production wasn't going to be fantastic and we were kind of in a sticky situation.
Yeah, and I think the key point there too is you had a couple of producing wells, but maybe some room for additional wells to come in. And so there was a big upside for somebody, a big carrot for them to get the payback if they were to have those wells get drilled and they were a non-operative working interest owner. It'd be a lucrative investment. So the thing to keep in mind is there's a lot to consider when you're learning about managing mineral rights, whether you're a beginning owner that has inherited property or if you're a beginning investor in minerals and royalties and you want to learn more about how to make sure that you're making good investments. If you're in those categories, that's who this course is for. And this just gives you a little bit of a taste of what to expect. Of course, we go a lot more in depth on other topics. I teach you how to perform a title search. Once you know what the legal description is of your property, you can then go and search for those interests on a map and understand where maybe there's oil and gas development occurring nearby, or if there are any producing wells on the interest that you are buying or that you inherited, so that you understand what the potential is there. So the outcome from taking this course would be that you would have a handle on what you own or what you're looking to own, and where it's located, what the oil and gas potential is, and then you'd have some basic tools in your tool belt in terms of how to identify where mineral interests are on a map, how to perform a title search, and then understanding the oil and gas potential of that property. Hopefully this was a helpful sneak preview into my mineral management basics course.
Go to mineralrightspodcast.com and click on courses to learn more and sign up today. Again, that's mineralrightspodcast.com and click on the courses link to learn more.
Thanks so much for listening to the Mineral Rights Podcast with your host, Matt Sands. Don't forget to subscribe and share at mineralrightspodcast.com. The Mineral Rights Podcast should not be construed as investment, legal, or tax advice. All information is believed to be from reliable sources. However, we make no representation as to its completeness or accuracy.